that introduction and for inviting me to make this presentation this afternoon. Good afternoon, everybody. Pleasure for me to be here today. For those of you who don't know me, I've been working in the area of personal health information for about 10 years now, I'd say. This is an outline of what I would like to talk about this afternoon. I'm going to start off talking about consent as a key principle in Ontario's Personal Health Information Protection Act, which I'll refer to as PHIPA. Then I'll provide you with an overview of the provisions of the legislation that relate to consent. I'll talk about circle of care and lockbox, which of course are two very important elements of the consent regime that's set out in PHIPA. I'll talk about the general limiting principles in the legislation because, of course, these apply even when you're collecting, using, and disclosing personal health information with the consent of the individual. And then I'll conclude by talking about some of the common pitfalls to avoid when you're obtaining consent. And these are things that we've learned from our experience at looking at other people's consent forms. As I'm sure you're already aware, Ontario's PHIPA came into effect November 1st, 2004, and it's based on Canada's Fair Information Principles, which are set out in the CSA Model Code for the Protection of Personal Information. And one of those key elements of those principles is, of course, consent. Now, before we had PHIPA in Ontario, at least part of the healthcare sector would have been covered by the federal private sector privacy legislation, PHIPA, or the Personal Information Protection and Electronic Documents Act. So as a part of the health sector that was involved in commercial activity, namely doctors' offices, would have been covered by that legislation. PHIPA was drafted to address privacy issues in the context of commercial activity, and the rules are not really applicable to the health sector. They're not appropriate for the health sector, especially the requirement for express consent in the context of sensitive personal information. And of course, this would include personal health information. So when PHIPA came into effect at the beginning of 2004, custodians in Ontario, health information custodians in Ontario, were particularly concerned about the application of the express consent provision in the context of the provision of health care. So they were opposed to being covered by that legislation, so Ontario worked quickly to get its own legislation in place. And of course, in order to be declared to be substantially similar to the federal legislation, which was necessary to exclude custodians from the application of the federal legislation, PHIPA had to meet the consent requirements of PHIPA. So it had to be consent-based, and the standard that was deemed to be appropriate for the healthcare sector was knowledgeable consent. So PHIPA was drafted quickly and in a manner such that the consent requirements would not delay or impede the delivery of healthcare. Now, since PHIPA was introduced at the beginning of 2004, of course, the Industry Canada, along with the Privacy Commissioner, has provided guidance on what it means, consent means in the context of healthcare. And they basically said that you can rely on implied consent when you're delivering healthcare to individuals. But at the time when PHIPA first came into effect, this was not clear. So the general rule under PHIPA is that a custodian can collect, use, and disclose personal health information if the individual consents or if the Act specifically permits or requires the collection, use, or disclosure without the consent of the individual. So you either have to have specific legal authority set out in PHIPA or the individual's consent, one or the other. Now, the legislation says that consent can either be express or implied, except where express consent is specifically required in the legislation. And whether you're getting express consent or implied consent, you still have to make sure all of the requirements for a valid consent have been fulfilled. Now, when do you have to have express consent? The legislation says that express consent is required when a custodian discloses to someone who is not a health information custodian. So, for example, if a doctor discloses to an employer or an insurance company, the express consent of the individual would be required. It's also required when a custodian discloses to another custodian for a purpose other than providing health care to the individual. So, for example, if a hospital is disclosing to another hospital for the purpose of its infectious disease control program, the consent of the individual would have to be obtained. And, of course, there's some requirements around marketing and fundraising as well. So the general rule is that custodians, in most cases, can rely on implied consent when they're collecting or using personal health information. However, when they're disclosing it, the general rule is that they have to get express consent unless they're disclosing to another custodian and it's for the purpose of delivering health care. So those are the general rules. Now, the elements of a valid consent, the consent has to be a consent of the individual or the individual's substitute decision maker, has to be knowledgeable, and I'll explain what that means in a minute. It has to relate to the information, and it must not be obtained through deception or coercion. And these requirements are set out in Section 18.1 of the legislation. Now, what does it mean to be knowledgeable? A consent to the collection, use, and disclosure of personal health information is knowledgeable if it's reasonable in the circumstances to believe that the individual knows the purpose of the collection, use, or disclosure, and that the individual may give or withhold consent. So this standard of consent is different from informed consent, where you informed consent for treatment, for example, where you'd have to know all the risks and benefits of the treatment that they're providing you with. So it's a different standard for the collection, use, and disclosure of personal health information. Now, the legislation also says that unless it's not reasonable in the circumstances, it's reasonable to believe that the individual knows the purpose of the collection, use, or disclosure if the custodian posts or makes readily available a notice describing these purposes where it's likely to come to the individual's attention. So you either have to post a notice or give the individual a notice of the purposes, and then you can rely on implied consent. Custodian can rely on a notice of purposes to support the reasonable belief that the individual knows the purpose of the collection, use, or disclosure. And if they wish to rely on the notice of purposes in order to imply consent, they have to post it where it's likely to come to the individual's attention, or they have to provide it directly to the individual. The notice has to outline the purposes for which the custodian collects, uses, or discloses personal health information, and it should also advise the individual that he or she has the right to give or withhold consent. Now, I should mention that a notice of purposes is not required where a health information custodian has the authority to assume an individual's implied consent. But it is considered to be a best practice even when you're relying on assumed implied consent. And I'll speak in a minute about what I mean by assumed implied consent. Now, this is an example of a notice that was provided in an attempt to fulfill the requirements of the Act relating to knowledgeability. Now, it's not very clear, but I'm sure many of you may have seen this notice. It was published in many newspapers. It's posted on the Ministry of Health's website, and it's going to be included with health card renewals very shortly in the future. But anyway, this notice was developed in the context of the Diabetes Initiative of the Ministry of Health and Long-Term Care. And in this particular case, the ministry wanted to disclose the names of patients with diabetes to their primary care provider. The primary care provider was supposed to validate the list of diabetics, send it back to the ministry. The ministry was going to use the OHIP claims database to create a report indicating the date when the individual had 3 tests that are required for diabetes management. So information was going to be going back and forth on the basis of implied consent, and individuals were given the opportunity to opt out, and the ministry provided this notice to individuals to inform them that this is what was going to happen, this is the purpose, and how the individual could give or withhold their consent. Now, I don't want you to confuse the notice that is provided in relation to the knowledgeability requirement for relying on implied consent. So there's another type of notice that's required under the legislation. It's called a written public statement. So Section 16.1 of PHIPA states that a health information custodian shall, in a manner that's practical in the circumstances, make available to the public a written statement that provides a general description of the custodian's information practices, describes how to contact the contact person for the custodian, describes how the individual can obtain consent or make a request for a correction of a record, and describes how to complain to the custodian and to the commissioner as well. Now, what's important from this is that the custodian just has to make this kind of statement available to the public. So there's no requirement for them to make sure it comes to the attention of the individual, as there is in the case of the notice that's required to fulfill the consent requirements. Information practices, you'll notice going back there that the first element of the public statement provides a general description of the custodian's information practices. So what does that mean? It means the policy of the custodian for actions in relation to personal health information, including when, how, and the purposes for which the custodian routinely collects, uses, modifies, discloses, retains, or disposes of personal health information, along with the administrative, technical, and physical safeguards, a description of those as well. So you can see that there are areas of overlap between the two kinds of notices. Both have to set out the purposes for which the custodian collects, uses, and discloses personal health information. Now, this is an example, again, from the Ministry of Health and Long-Term Care. I pulled it off of their website. It's their statement of information practices. So it's not in the context of any particular program or initiative. It's their general statement that describes their information practices, tells you what the purposes are for the collection, use, and disclosure, tells you where to go for additional information, and it tells you how to make a complaint to both the ministry and to the Office of the Information and Privacy Commissioner as well. So it's not very clear, but you can look at that on the ministry's website. So this is different. They've posted on their website, but basically it's buried on their website, and unless you really look for it, you'll never find it. But the other notice, they actively had a communication strategy for that. So it's posted in newspapers, it's going to be in the health card renewal notices, and it's on their website as well. The IPC has also developed a number of products to help health information custodians fulfill their notice requirements. We call these our short notice products. We have these available for hospitals, for small offices, and for long-term care facilities. And basically, within each domain, there's 2 products. There's a written brochure with more detailed information, and then there's a notice that can be posted, like a poster, that can be posted within the office or within the facility. And it has the basic essential information. For more detailed information, it refers you to the brochure. So just to sort of recap, custodians can rely on express or implied consent, especially when they're collecting and using personal health information. They can rely on implied consent. When they're disclosing information, they generally require express consent. However, for the purpose of providing health care, when they're disclosing to other health information custodians, they may rely on implied consent. And to fulfill the requirements for a knowledgeable consent, custodians can post a notice or make the notice available to the individual. Now, there's another kind of consent that is mentioned in the legislation. This provision of legislation is often referred to as the circle of care provision or the assumed implied consent provision. And basically it says that certain custodians, and it's only those that are directly involved in the delivery of healthcare to the individual, they are allowed to assume that it has the individual's implied consent to collect, use, and disclose personal health information for certain purposes in certain circumstances. Now, the only exception would be where the custodian is aware that the individual has withdrawn his or her consent. So the inclusion of this provision, the circle of care provision, further emphasizes the fact that consent requirements of PHIPA should never delay or impede the provision of health care to the individual. Now, the IPC has launched a guide to clarify the circumstances in which custodians are allowed to rely on this assumed implied consent and the options available when the custodian cannot rely on this assumed implied consent. I should also mention that the term circle of care is not a defined term in the legislation. It's not even mentioned in the legislation. It's the term that's commonly used to describe this assumed implied consent idea. When we were developing that brochure, we had a fairly comprehensive working group made up of the Ontario Medical Association, the Ontario Hospital Association, the College of Physicians and Surgeons of Ontario, the Ministry of Health and Long-Term Care, the Ontario Association of Community Care Access Centres, Ontario Long-Term Care Association, Ontario Association of Non-Profit Homes and Services for Seniors. So the healthcare sector was fairly well represented when we were developing that brochure. This is what the brochure looks like. It's available on our website, and there's also very nice hard copies that are available if you call my office. And I think it's been our bestseller in terms of our communications products. So basically, if you want to rely on assumed implied consent within the circle of care, the custodian has to fall within the category of custodians that are entitled to rely on assumed implied consent. The information must have been received from the individual, from the individual substitute decision maker, or from another custodian. The information must have been received for the purpose of providing health care to the individual. The purpose of the collection, use, or disclosure must be for the purpose of providing health care, and disclosures must be to another custodian, so you cannot include family members and other people within the circle of care. And the custodian that receives the information must not be aware that the individual has expressly withheld or withdrawn consent to the collection, use, or disclosure. So these are the key components of assumed implied consent, and they're set out in detail in that brochure. Now, you'll notice that information flows for the purpose of providing health care unless the individual specifically takes some action to withhold or withdraw consent or give an express instruction not to use or disclose personal health information for the purpose of providing health care. So there's two components to the lockbox. One is the withdrawal of consent, and the other is the express instructions. And I'm going to talk about the withdrawal of consent first. There's two provisions that relate to that. Section 19(1) of the legislation says that if an individual consents to have a custodian collect, use, or disclose personal health information, the individual may withdraw consent, whether it's express or implied, by providing notice to the custodian. So that's the general withdrawal of consent provision. Now there's also section 20 sub 2, which is the assumed implied consent provision, or the circle of care provision, which says that certain custodians who receive personal health information for the purpose of providing health care is entitled to assume it has the individual's implied consent unless the custodian is aware that the individual has expressly withheld or withdrawn consent. So information flows unless the individual takes some action. And you'll note that the withdrawal of consent or express instructions do not have to be in writing. So you just have to provide notice, and this could, of course, be verbal notice. With respect to express instructions, there's 3 sections that include this type of provision. Section 37(1)A, which says custodians can use personal health information without consent for the purpose for which it was collected, which is, of course, for healthcare purposes, but not if the individual expressly instructs otherwise. Similarly, Section 38(1)A says custodians may disclose personal health information without consent to certain custodians if the disclosure is necessary to provide health care and it's not possible to obtain consent in a timely manner, but not if the individual has expressly instructed the custodian not to make the disclosure. And then the final one, I think it has to do with disclosures outside of the province, but it's similar to the ones I've already described. Custodians may disclose personal health information without consent if the disclosure is necessary to provide health care, but not if the individual has expressly instructed the custodian not to make the disclosure. So that is the lockbox. Now, the individual has to provide notice to the custodian. Again, as I mentioned, it can be verbal or in writing. However, an individual cannot place a condition on his or her consent to have a custodian collect, use, or disclose personal health information that prohibits or restricts any recording of personal health information that's required by law or by established standards of professional practice or institutional practice. So, for example, we know that healthcare providers are required to document the information upon which they make their treatment decisions, and there's nothing that the individual can say or do in terms of withdrawing their consent to prevent the healthcare provider from documenting that information in a person's record. However, there are no other conditions or restrictions placed on an individual who wishes to withhold or withdraw consent or provide an express instruction. So it's a very, very broad right of the individual to withhold or withdraw consent or give an express instruction. It only applies in the context of delivering health care, but it's a very broad right. I also want to mention that if you cannot rely on assumed implied consent, there are some other ways that you can go about collecting, using, and disclosing personal health information. So you should look to see, first of all, if the collection, use, or disclosure is permitted under PHIPA without consent. And PHIPA does permit a broad range of collections, uses, and disclosures without the consent of the individual. They're set out in the legislation in detail. Custodians can also rely on implied consent, not assumed, but implied consent for most purposes. They have to make sure that all the elements of consent are met, and they have to provide the notice to make sure that the consent is, implied consent is knowledgeable. And when collecting, using, and disclosing personal health information for purposes other than providing health care, or when disclosing to a person other than a health information custodian, custodians are required, of course, to get the express consent of the individual. And I should also mention that even where the individual withholds their implied consent or their assumed implied consent, so they may say that they don't want their information to flow, you can still get their express consent to do it. So it doesn't mean that information can never flow. It just means it can't flow on the basis of assumed implied consent or implied consent. Now, the general limiting principles in the legislation also apply when you're collecting, using, and disclosing personal health information. Even if you have the consent of the individual, you have to minimize collection. Section 31 says that a custodian may not collect, use, or disclose personal health information if other information would serve the purpose. So this means that if de-identified information or, for example, aggregate information would serve the purpose of the collection, use, or disclosure, that's all you're permitted to collect, use, or disclose. Similarly, custodians cannot collect, use, or disclose more personal health information than is reasonably necessary to meet the purpose. So if you don't need certain elements or certain fields in a database, don't collect them. So these principles continue to apply even when the custodian relies on assumed implied consent. Now, I want to talk about some common problems in the consent forms that we've seen in my office. One common problem is that custodians will include in their consent to treatment form notices about the purposes for the collection, use, and disclosure of personal health information without distinguishing between what's consent for treatment and what's a notice of purpose. And this can be confusing for individuals because individuals might believe that they're providing express consent for the collection, use, and disclosure of personal health information, when in fact the custodian may be relying on implied consent or assumed implied consent. Custodians should therefore ensure that individuals understand that the express consent relates to the treatment and that personal health information will be collected, used, and disclosed for the purpose of providing health care unless the individual expressly withholds or withdraws their consent. Another common problem is that some custodians include in their consent to treatment forms consent for the collection, use, and disclosure of personal health information for secondary purposes, such as research, without distinguishing between the two. So if the individual wants to receive treatment, they have to sign this form, but in signing this form, they're also expressly agreeing to the collection, use, and disclosure of their personal health information for other purposes that are not directly related to the provision of health care. And I've seen many, many forms where this is a problem. Excuse me. Now, this type of consent, where you condition the treatment of the individual upon them agreeing to all these other collections, uses, and disclosures of their personal health information, may not, in fact, fulfill all of the requirements of consent. And in particular, I'm thinking about the requirement that the consent not be obtained through coercion. So if you're forcing people to agree to all these other uses and disclosures of their personal health information just because they're receiving treatment from you, that may not meet the requirements for consent. So the tip is that custodians should ensure that individuals understand that they may give or withhold their consent to the collection, use, and disclosure of personal health information for each purpose, and that treatment is not dependent upon their consenting to the collection, use, and disclosure of their personal health information for other purposes that are not directly related to the provision of health care. And the last pitfall that I want to talk about is that some custodians combine notices to ensure that consent is knowledgeable with notices of the purpose for which personal health information may be collected, used, or disclosed without consent, without distinguishing between these two things. So there's certain things that custodians can and will do with the information regardless of whether or not you're consenting to it. But individuals may be confused and think that they can give or withhold their consent for all of these collections, uses, and disclosures, when in fact they cannot. So to avoid this pitfall, custodians should ensure that individuals understand the circumstances in which they may give or withhold their consent, or give an express instruction not to use or disclose personal health information. Okay, so just to wrap up, the consent provisions of PHIPA were drafted in a manner such that consent should never delay or impede the delivery of health care. So you can rely on implied consent in most circumstances. It's in the context of delivering health care, you never really are required to get express consent. Custodians may rely on implied consent in most circumstances, as long as all the elements of consent are met, including the knowledgeability requirement. And in order to fulfill the knowledgeability requirement, a custodian may post a notice. In some circumstances, certain custodians within the circle of care may rely on assumed implied consent when collecting, using, disclosing personal health information for the purpose of providing health care. Whether a custodian is relying on express consent, implied consent, assumed implied consent, or no consent, the general limiting principles continue to apply. And in the context of providing health care, individuals may withhold or withdraw their consent or give an express instruction not to collect, use, or disclose personal health information without their consent in those circumstances where the custodian is authorized to do so, simply by providing some sort of notice to the custodian. And the notices of purposes should ensure that individuals not only understand the purpose, but also the circumstances in which consent may be withheld or withdrawn. So basically, that's all I wanted to say. So I'd be happy to respond to any questions, or if you want additional information, you can contact my office. That's our website. You can contact by phone or by our website. Thank you.
Okay, well, thank you very much, Debra. So now the text box should appear on your screen, and if anybody has questions, please type in your questions, and then Debra will be able to see them online, and she'll respond to them. My only request, Debra, is if you can read the questions that the question that you're answering, so that all the other attendees can know what the question is. I think they're starting to come in now.
There's a question about receiving a copy of the presentation, and I think that you're going to provide that, Khaled?
Yes.
Yeah, a copy of the presentation will be provided. I might take out the two slides about the notices from the Ministry of Health. I don't want to, violate any copyright laws or anything of that nature. But other than that, the presentation can be available. Another question is, does the notice of purpose have to include the actual names of the legislation? No, it does not have to specifically include, for example, PHIPA, but it would be helpful for individuals to understand under what authority you're collecting, using, and disclosing personal health information, so it might be helpful to refer to that. There's nothing in the legislation that says you need to specifically refer to the legislation, but I think most notices do mention the legislation. I don't know if I'm reviewing these in order or not. I have a question from somebody about the requirements for substitute decision making. There's a whole section in the legislation that says who can be a substitute decision maker for the individual and who can provide consent on behalf of the individual. That's a whole separate presentation in itself, but it's all set out in detail in the legislation. I don't know if you wanted to ask something more specific about that particular issue. The presentation will not, somebody's asked if the presentation will be posted on the IPC website, and no, this particular one will not be. Khaled, maybe you could provide more information about where it's going to be posted.
Yes, it'll be posted on our website, and you will receive an email as soon as it's available. You will receive an email letting you know where it is. But it'll be in the section where all the webinars are posted.
I have a question. How do the consent and notices work when acting as a health information network provider under PHIPA? So health information network providers under PHIPA are a specific class of service providers that are mentioned in the legislation. Basically, a network provider is somebody who provides electronic services to two or more health information custodians that enable them to share personal health information. Now, a health information network provider would be providing those services on behalf of a health information custodian, and they would only be permitted to collect, use, or disclose personal health information as they have been authorized to do so by the health information custodian, and there would be an agreement between the health information custodian and the health information network service provider setting out in detail the purposes for which the network provider can collect, use, or disclose personal health information. So it's the custodian that has the obligation to provide the notice. Health information network providers have certain information that they have to make available to the custodians, and but basically it's the custodian that has the obligation for the notice. Another question, how are lockbox principles to be reflected in Ontario's electronic health record. That is something that hasn't been worked out in detail at this point in time. I can tell you how they're working in the context of certain e-health initiatives. For example, in the context of the drug profile viewer of the Ministry of Health and Long-Term Care, which is basically people who are on Ontario drug benefits, their information about their drug histories is made available to hospitals. And if individuals don't want that information used for that purpose, they can contact the ministry and have their names, have their information locked or masked so that none of the information is available. They can also mask specific drugs that they don't want people to know about in their record as well. So that's how it's working in the context of that initiative. In the context of OLIS, individuals can withdraw their complete consent from having the information available, except to the physicians that requisition the lab test, or they can contact the lab to withdraw consent for specific lab tests. So that's how it's working in those initiatives. It's not clear how it's going to work when we have an electronic health record throughout Ontario, but that's something that the Ministry of Health is considering at this point in time. I have like 1 million questions here. Okay, I answered that one. Somebody's asked me about my opinion on the preferred procedure to obtain consent from patients. The pre-screening of their charts for research eligibility and to be contacted. This would not be a request for a patient's actual participating in a study. It would only be to review their chart for eligibility. Now, if you're, I don't think it's practical for researchers to get consent from the patient before they screen their chart for eligibility for participating in a research project. I think that the general procedure would be to have a research ethics board approve the waiver of the consent requirement for that specific aspect of the research protocol. And they may or may not approve the use of the information for the protocol beyond that, but for that aspect of the protocol, they should approve a waiver of consent requirements. And then, depending on the protocol, the consent of the individual can be obtained when they're contacted. Of course, it has to be, if you're asking individuals to participate in research projects, the custodian is required to contact the individual first to ensure that they're willing to be contacted by a researcher. That's a requirement in the legislation. So in general, I think that if you're going to be screening charts for eligible research participants, that should be done with REB approval of the consent waiver. Another question, can research staff be included in the circle of care, since many provide health care to participants during their participation in the research? Now, this is a question that gets asked quite often. The circle of care only includes people who are providing health care to the individual. If the researcher is being included because they're providing health care to the individual for a research project, then that would not be considered to be within the circle of care. But you have to draw a line between, are you providing health care to the individual, or are you engaging the individual in your research? So you have to distinguish between what it is that you're doing. So if it's a clinical trial, for example, and it's a research protocol, you wouldn't be getting information on the basis of assumed implied consent, because individuals would have to consent to participating in that. They'd have to provide their express consent, and I don't think you'd be relying on assumed implied consent and be considered to be within the circle of care for those purposes. So that's, if somebody wants to ask a more detailed question about that, I'd be happy to provide more information. Another question, does the legislation state where the notices need to be posted? No, there's no details about where the notice needs to be posted. It has to be posted in a place where it's likely to come to the attention of the individual. And I know many hospitals post notices in waiting rooms. Doctors' offices often post notices in waiting rooms as well. Some healthcare providers actually just provide the notice to the individual directly, a written notice to the individual directly. There's no, whatever you think is reasonable, the custodian has to determine on a case-by-case basis where it's reasonably likely to come to the attention of the individual. Another question about research coordinators being part of the circle of care. I don't consider research coordinators to be part of the circle of care. They're not delivering health care to the individual, and I don't think they should be included in the circle of care. There may be some exceptions to this or some circumstances in which they would be in part of the circle of care, but it's important to distinguish between when you're providing health care to the individual and when you're conducting research. It's really important to draw the line between those things, because the requirements of the legislation are very, very different. With regards to the problems that you have witnessed with some consents for treatment and PHI are mixed and there is difficulty in distinguishing the two, would having two separate consents be a better process to having a consent for separate consent for PHI? It could be on one form as long as you separate the two things out. But I think it is better to have a separate form. And in most cases, you're not going to be requiring consent at all in the context of providing health care. So you may require a written consent, informed consent for consent to treatment. But if you're talking about the collection, use, and disclosure of personal health information for healthcare purposes, you usually don't have to have any kind of consent, and if you're relying on assumed implied consent, you don't even have to provide a notice to individuals. So if you are providing notice, for example, if you're providing notice that you're going to be using their information for research, let's say, or for whatever, then it might be a good idea to keep it on a separate form, or at least separate it out so people are aware of what they're consenting to and what they have the opportunity to withhold their consent to. Does PHIPA? Somebody's asked me if PHIPA refers to research ethics boards and research. Yes, they're both defined in the legislation. A research ethics board is the composition of the research ethics boards, and the role of the research ethics board under PHIPA is actually set out in the legislation. Almost all of the research requirements, particularly with respect to disclosure, are set out in Section 44 of PHIPA, and there's quite a few requirements that are set out in the regulation that accompanies PHIPA. It defines the composition of a research ethics board. It says what has to be in the research plan. So both research ethics boards and research are defined in the legislation, and there's quite a bit of detail in the legislation about those. Another question, when the personal health information being collected, used, disclosed as a requirement under PHIPA or other laws, does a notice of purpose still need to be provided, even though consent is not being sought? No. If you're authorized to collect, use, or disclose personal health information under PHIPA or under another law, you're not required to provide notice of the purpose at all. That requirement does not apply. No. New requirements for waiver of consent for incapable subjects enrolled in urgent research studies. Oh my goodness. Again, this would have to, incapable subjects, there would have to be a substitute decision maker involved if you were getting consent. So if you have a waiver of consent, I'm not sure about the ethics of this. To me, this is not a privacy issue. This is an ethical issue. So I'm not sure about a waiver of consent for incapable subjects. I'm not sure about that. I don't think the legislation addresses it, and I don't really think it's a privacy issue. I think it's an ethics issue. So I'm not going to respond to that. If somebody wants to send me an email afterwards, they can send me an email, and I'll have a discussion with them about that. Under PHIPA, under PHIP and PHI, be sent through cloud computing. Oh, yes, personal health information will definitely be sent through cloud computing. Again, the custodian is responsible for the information that's in their custody or control. So whether they're using service providers outside the country, they have to take reasonable steps to ensure that that information is secured. This really goes beyond consent, so I don't think I'm going to get any further into that, just to say that the custodian is responsible for the security of the information regardless of where it's retained. Completing a questionnaire qualify as implied consent for a non-intervention. So yes, well this has to do with, if it's consent-based research, it really falls outside the scope of PHIPA. So as long as the consent is a valid consent, it wouldn't really be covered under PHIPA. And if it's a health information custodian that's collecting, using, and disclosing the information, they would have to meet the elements of consent that are set out in Section 18 of PHIPA. But I think that when someone completes a questionnaire, as long as they know they don't have to complete the questionnaire, that they're doing it of their own free will, that would meet the requirements for implied consent by a health information custodian. But if you're asking me a question about research in general that goes beyond PHIPA, I can't really comment on that. Are researchers allowed to create databases, and must it be included in the consent form? Can they use this information only for this particular project, or can it be used for future projects? Well, I'm not exactly sure if you're creating a data, if you're collecting, using, or disclosing personal health information for research purposes. If you're a health information custodian, you have to meet the elements of consent, as I said. If it's not consent-based, then you have to worry about the Research Ethics Board approval. But the consent-based research is not really governed by any other aspects of PHIPA. If it's custodian, you just have to meet the requirements for consent, and then you can do whatever you want with that information. It says, can the use of this information only for this particular project, or can it be used for future projects? Well, that depends on what kind of consent you've got and what people have consented to. So if they've consented to you using it for a variety of projects, you would still have to make sure that the consent meets all of the requirements. So it's really hard to do a good consent form that covers off all future uses of projects, but I don't think it's impossible. And I know there are some long-term health research projects that are ongoing right now where they're collecting consent upfront, and there's going to be a variety of uses of the information. So I think it's possible to do it in a consent form, yes. And the fact that you're creating a database, I'm not sure if you have to say that explicitly, but you have to make it clear what you're going to be doing with the information and what safeguards would be in place for the information. I have a question. Consent statements and verbal scripts when collecting over the phone often needs to be at the grade 6 or lower level of literacy. Is there suggested wording on this that would still be compliant with PHIPA? as I said, the consent requirements in PHIPA are that they have to understand the purpose, and they have to understand that they can give or withhold consent. They have to know what information is involved, and it has to be a consent of the individual, and it can't be done through coercion or deception. So as long as all those requirements are met, I think you could do it at a grade 6 level for literacy purposes. I don't have suggested wording, but if you want to contact me afterwards, and we can discuss your particular your particular needs in more detail, I can maybe offer you some guidance around that. Prescribed entity. Somebody has asked me to speak a little about prescribed entities for access to patient charts for research, and is there expiry dates for a prescribed entity? Prescribed entities are certain organizations that are prescribed in the regulation that accompanies PHIPA. We have 4 prescribed entities: Cancer Care Ontario, the Canadian Institutes for Health Information, the Institute for Clinical Evaluative Sciences, ISIS, and the Pediatric Oncology Group of Ontario, POGO. So we have 4 of them, and those organizations are permitted to collect personal health information from health information custodians without the consent of the individual, provided that they meet certain requirements, the most important being review and approval of their information practices by my office every 3 years. So those approvals expire every 3 years, but they renew those after every 3 years. And in fact, this year, by October 31st, all of the prescribed entities and registries are going to have their new approval letters so that they can continue to collect, use, and disclose personal health information without the consent of the individuals. Now, those prescribed entities are permitted under PHIPA to disclose personal health information to researchers. They're allowed to use it and disclose information for research purposes, provided that they meet the requirements that all health information custodians are required to meet. Specifically, they're required to create a research plan and to have it submitted to an REB and approved by an REB, and they're required to have a research agreement with the researcher as well. So they're allowed to disclose as if they were, so use and disclose the information for research purposes as if they were health information custodians. So researchers, most of those prescribed entities do not, however, disclose identifiable data to researchers as a matter of policy, even though they have the legal authority to do so. As a matter of policy, they don't generally do it. They'll do matching and disclose de-identified data, for example, to a researcher. How does consent fit within the privacy by design principles of the IPC? Well, consent is more like a fair information practice. So if you can build consent into your whatever it is that you're designing, an information system, a new policy and procedure, whatever you're designing, if you would have to fit, it should be based on consent. And individual control is one of the key principles of privacy by design, and of course consent is central to that, the individual exercising control. I have a question for OLIS and the drug profile viewer and other electronic health records. Can patients specify specific physicians or providers that they would like to mask their information from? Now, my understanding is that they cannot. They can bring, I think in the context of OLIS, they can unmask information for specific health information custodians, but they can't pick and choose who they want to have access and who they don't want to have access. So this is something that is going to be worked out as we move towards an electronic health record for the entire province. All of these details of how much granularity can be built into the consent process reasonably and practicably. But right now, in the context of those systems, they have all or nothing and test level masking, and I don't think they have provider level masking, but this is something that is being considered for the future. And of course, you know, custodians are not required to implement all of the requirements of the legislation within an electronic system. For example, they may choose to do parts of a lockbox manually. If they can't manage what the individual is requesting in the electronic environment, they may have to take it out of that and keep it in a paper-based environment where they can manage it. I have a question here for a litigation guardian. What due diligence needs to be done to see legal documentation that a litigation guardian is in fact that? What extent does HIC have to, can the HIC ask for a copy, or must they have a copy of do the legal? This is a question about substitute decision making, and I think that the health information custodian is generally allowed to rely on the assertion of somebody that they are in fact the legitimate substitute decision maker for an individual, unless it's not reasonable to do so, of course, or if there's any dispute about who the guardian is, they may wish to see legal papers, legal documents, or if that's not available, they could probably, they may, I think in some cases, the tribunal has asked them to produce a affidavit stating that they are in fact the legal guardian or the substitute decision maker for the individual. But that would have to be determined on a case-by-case basis, and what under the circumstances, you know, what's reasonable. But I think they're allowed to rely on somebody's assertion for cases. If somebody wants to contact me later about that, I can confirm that information, because I'm not an expert on the substitute decision-making rules. And some of those rules go well beyond PHIPA. I have another question. How are we doing for time, Khaled?
Well, it's 1 o'clock now, so I can see you still have quite a few. I think the best thing would be maybe if you can scan. Yeah, there are really quite a few left to go. Do you have time to answer a couple more and then?
I have time. I'm not worried about me. I'm worried about whatever.
There's still quite a lot of people online. So if you have time, we can keep going.
Okay. Okay. I have a question. Does the use of patient data that has personal information removed for the purpose of research require client consent? No, it does not under PHIPA. In fact, if you remove all the personal health information, and the standard in the legislation is that the individual cannot, it must be reasonable in the circumstances that the individual cannot be re-identified. If you meet that standard, the information falls outside the scope of the legislation completely. And that standard is set out under the definition of personal health information. So what's identifiable? So as long as you can de-identify the data, it falls outside the scope of the legislation, and health information custodians can collect, use, or disclose de-identified information for whatever purposes they like. It's not covered by PHIPA. I have a question. Does PHIPA refer to the Tri-Council policy statement? Of course, no, it does not. But it was the rules in PHIPA for research were designed keeping that policy statement in mind. So I don't think there are a lot of inconsistencies between what's in PHIPA, the requirements in PHIPA, and the requirements in the Tri-Council policy statement. However, I would say that that statement is not legally binding, whereas the requirements in PHIPA are legally binding. So PHIPA would have to take precedence if there were a conflict, but I don't think there is any conflict because they were aware of that policy statement when they developed those provisions for research in PHIPA. Another question, mandatory reporting is required under the Health Protection and Promotion Act for reportable diseases. Does PHIPA require that obtaining express consent be attempted, even if the disclosure is required by law? And I would say no, that if it's required by law, the consent provisions do not apply. In addition, I would say that even the general limiting principles do not apply to a collection, use, or disclosure that's required by law. So if you're required to do something by law, you don't have to get express consent, even if it's feasible in the circumstances. You may do it as a best practice, but what if the individual refuses to provide their express consent, and then you go ahead and make the disclosure anyway because you're required to do it? So in that particular case, I think the best practice would be just to let them know, if you want to be transparent about what you're doing, let them know that you're required to make this disclosure and that you're going to make this disclosure. Another question, does PHIPA have similar HL7 messaging requirements like the Health Insurance Portability and Accountability Act? No, we don't have any specific requirements. We have a very, very general requirement about security, and let me see if I can just pull that provision up right quickly. It basically says that a custodian shall take steps that are reasonable in the circumstances to ensure that personal health information in the custodian's custody or control is protected against theft, loss, and unauthorized use or disclosure, and to ensure that the records containing the information are protected against unauthorized copying, modification, or disposal. Now, the IPC has put out guidance in some respects about the security requirements and what we expect, and also there's some guidance in our orders, but the legislation itself does not have any details on anything in the same manner as the privacy legislation from the U.S. has. Another question, what would a health information network provider's obligation be in regards to managing consent directives on behalf of a HIC? How would a health information network provider build, design, I can't read this very well, the ability to collect consent into an EHR or system which the HIC uses? If there are multiple HICs using an EHR or a system who want to manage consent in different ways. I have no clue. I can't answer that question. The obligations arise under your agreements with the health information custodians. And before custodians can share information, they would have to agree on what those standards are going to be, because they're going to have, the way the legislation is written now, if you're collecting, using, or disclosing that information, you have some accountability for that information. So in the context of a shared record, there's going to be shared accountability. And there has to be some sort of formalized agreement about what the rules are going to be in that context. So it's not up to the health information network provider to determine that. It would be up to the custodians to agree upon certain standards in a shared record. So in the context of the provincial electronic health record, I'm not sure what the rules are going to be. However, there's going to have to be a whole governance structure setting out what the rules are going to be, who's going to have access to that information, how are breaches going to be handled in that context, how is the consent going to be managed in that context. There's a whole governance framework that needs to be put in place, and it's my understanding that there will be a requirement to have amendments to PHIPA or separate legislation to address those huge governance issues. But the way the legislation is right now, the custodians are accountable, and they have to agree to certain standards because it's up to them to take reasonable steps. So they have to ensure that everyone's following rules that are acceptable to them. Another question, can we pre-screen every patient admitted to the hospital without consent to see if they are eligible for any type of research project? This is not in relation to a particular protocol. Well, there's no provision in PHIPA that says you can collect or use personal health information for screening for research projects. So it's not a permitted use or disclosure without the consent of the individual. So you either have to have Research Ethics Board approve the waiver of consent, or you have to have the consent of the individual. So there's you cannot do that without consent or waiver from the Research Ethics Board. And I know hospitals like to do things like this, but they should not be doing it without the ethics approval. Another question, what does PHIPA say about messaging? Oh, I have this question already. It doesn't say anything about it. Please explain further how the Ethics Board can waive the consent for a chart. Okay, the Research Ethics Board is required to review the research plan, and there's very specific requirements that are set out in the regulation that accompanies PHIPA about what has to go into the research plan. And then it's up to the Research Ethics Board to consider, and I'm trying to find this section of the legislation, because I wasn't planning to talk about that today, but let's see if I can find it. It's in section 44. Okay, section 44.3, sub 3 of PHIPA sets out what the Research Ethics Board is required to do, and this is a legal obligation to do this. When deciding whether to approve a research plan that a researcher submits to it, a Research Ethics Board shall consider the matters it considers relevant, including whether the objectives of the research can reasonably be accomplished without using personal health information that is to be disclosed. So can they do the research with de-identified or aggregate information? They have to consider whether there's going to be adequate safeguards in place to protect the information. And if there's not going to be adequate safeguards, they should refuse reject the research plan. And the public interest in conducting the research and the public interest in protecting the privacy of individuals' personal information is disclosed. So this means they have to do some sort of assessment of the benefits of the research compared to the privacy risks that are associated with the research, and make sure that the benefits of the research outweigh any privacy risks that are posed to the participants. And then the last thing they have to consider is whether obtaining the consent of the individual being disclosed would be impractical. And if it's practical for them to get consent, of course they should require a consent, that consent be obtained, but if it's not practical, they can approve the waiver. So those are the things that the board has to take into consideration when approving the waiver of consent. And it's set out in section 44 sub 3.
So Debra, I think we'll try to close it now, if you
Okay.
don't mind. But I just, as a last question, if I may ask one last question, I wanted to bring up the issue of data warehouses.
Right.
And what are the consent requirements for the creation of data warehouses where then within hospitals, let's say, and then the data is subsequently used for other purposes?
Well, I'm not sure under what legal authority, like what provision of PHIPA allows, let's say, for example, a hospital that wanted to create a data warehouse, allows a hospital to use the information for that purpose. And it also depends on, what the purpose of the data warehouse is. There's a lot of uses of the information that you can make under PHIPA, but those are all very specific. So a data warehouse for non-specific purposes, I'm not sure under what legal authority they would use the information for that purpose, or they'd be able to use the information for that purpose. For example, if it was for improving the quality of care under section 37(1)D, which is a permitted use, then yes, they could create the warehouse for that particular purpose. But I don't think that they could create it for just, to make it available for a broad range of purposes, unless they had the consent, of course, of the individual.
Okay, great. Well, thank you very much, and I appreciate everybody who stayed with us until now. Just in closing, I would like to mention again that we will be making the presentation slides available and the recording of the whole session. And also to let you know that we have a webinar series with quite a few webinars being organized later this month and in June. In the next email, you'll get informing you that the materials online. You'll get a link to some of the other webinars. So please feel free to join us again in the future. I think if this topic was of interest to you, then the other ones I think would also be of great interest to you. They all deal with privacy and ethics issues. So again, thank you very much, Deborah. I really appreciate you taking the time today. And I think if anybody has any other questions for Deborah, they can send her an email directly.
And I also want to mention that we do have 2 people in my office that respond specifically to PHIPA questions. So if you call our general line and ask for somebody in communications who can respond to, they can respond to many of these questions, and they can either do it through our website or through calling our general line, or send me an email directly, either one.
Okay, excellent. Thank you very much.
Okay, thank you, Khaled.